Chief Justice, Associate Justices, and may it please the court. Good afternoon. I, Breean will be representing the respondent in the case before the court today. The issue before this court today is, does the Second Amendment prohibit New York from requiring residents who wish to carry a concealed firearm in public to have an actual and articulable need to do so? The answer to that question is an unequivocal yes. We respectfully request that this court uphold the court rulings since the beginning of the Republic and allow the land of the law, the Second Amendment, to be the rule of the law. With this in mind, the United States federalization should not interfere with the rights of the state in this issue. The strict scrutiny standard of judicial review is based on the Equal Protection Clause of the 14th Amendment, the Second Amendment, and the 10th Amendment. Federal courts use strict scrutiny to determine whether certain types of government policies are constitutional or not. There comes in the course of time that particular time to where very important issues face this country. This is clearly one of those times. In essence, this case goes to the very core of the foundation of the United States. We are the United States of America. We are a collection of 50 individual states that make up one country. We are not one country where you can do anything you want. We are a country of laws and rules. The greatest and overriding law of the land is the U.S. Constitution. Therefore, we stand before you today to support the Constitution and insist on the rights of the state to do their jobs in question. Since the concept of the right to bear arms does not apply in the U.S. Constitution, it falls under the 10th Amendment, a state's right issue. Then cross-apply the fact that the Second Amendment ties to the right to bear arms to the fact of the state militia. Clearly, the state has the ability here to modify the rights of their citizens to use their arms. This is a state's right issue, and the only way to uphold the Constitution today is to vote for the respondent in this case. Debunking the individual rights hijackers of the Second Amendment, Professor Cornell from Ohio State University refers to the, quote, often quoted passage describing the Second Amendment as the pedalium of liberty, at least 5 times, but strangely fails to provide the actual quotation or acknowledge its contents. It would be worthwhile to do so at the outset in order to determine the extent of the constitutional hijacking by scholars who read the Second Amendment as it's protecting individual rights. This may be considered as true pedalium of liberty. The right to self-defense is the first law of nature. In most governments, it has been the study of rulers to confine this right within the narrowest limits possible. Whenever standing armies are kept up and the right of the people to keep and bear arms is, under any color or pretext whatsoever, prohibited, liberty, if not already annihilated, is on the brink of destruction. Cornell's thesis is that Tucker, along with the founders in general, saw the Second Amendment as guaranteeing a state right to maintain a militia, excluding an individual right to have and carry arms for self-defense, which the legislator is free to curtail or prohibit. In this concept of an individual right was not the original intent of the framers of the Constitution or the understanding of the people who constructed the Bill of Rights. Robert Nash and Brandon Koch each applied for a concealed carry firearm license for the purpose of self-defense. The licensing officer denied both applications, finding that neither individuals met the proper cause standard required by New York law in order to issue a firearms license for general self-defense. New York courts have defined proper cause as requiring the applicant to demonstrate a special need for self-protection, distinguishable from that of the general community. Both Nash and Koch were denied their permits, and this created the problem. This brings up the question before the court today, to which the answer is the Second Amendment does not prohibit the states from denying a law-abiding person to a license to carry a handgun outside of the home. The facts of this case are, number 1, the founders would have made the individual right aspect of the Second Amendment expressed if that was what was intended. Number 2, the militia preamble demands the conclusion of the Second Amendment touches on states' militia services only. Number 3, the many lower courts later collective right reading of the Heller decision constitutes a change in state decisions. The court has not considered gun control laws, for example, the National Firearms Act, unconstitutional, and only the state should have the power over the militia. The founders would have made the individual right aspect of the Second Amendment expressed if that was what it was intended for. The right to bear arms goes back to the time of the Revolution, but clearly the founding fathers did not think it was a standalone individual right. Of the original 13 states, the idea of the Second Amendment was non-existent in these states. New York, New Jersey, Maryland all had no mentions in their constitution. And the following states mentioned the right to self-defense in their constitutions. Massachusetts says the people have a right to keep and bear arms for the common defense. And as in time of peace, armies are dangerous to liberty. They ought to be maintained without the consent of the legislator. And the military power should always be held in an exact subordination to civil authority and be governed by it. Virginia says that a well-regulated militia composed of the body of the people trained to arms is the proper, natural, and safe defense of a free state. That standing armies in time of peace should be avoided as dangerous to liberty. And that in all cases, the military should be under strict subordination and governed by the civil power. Your Honor, please classify all of my facts, arguments, and court case sites. And if there are no further questions, we will retire and allow our opponents the ability to argue their case. We pray that you vote for the respondent in this case.
What does the Second Amendment protect?
A well-regulated militia being necessary to the security of a free state, the rights of the people to keep and bear arms shall not be infringed. What this means is that the Second Amendment protects the ability of a state to protect its citizens. Note, like we mentioned before, it clearly states that the United States is not a singular state, and which is unitary or federal. Because of such, the United States federal government cannot rule today against the state in this case without taking the 10th, the 2nd, and the 4th Amendment. In effect, they would reverse Marbury versus Madison and judicial review itself.
Why did the framers include the Second Amendment in the Bill of Rights?
The United States was in jeopardy of being invaded by England. In fact, on August 24th, 1814, a British force led by Major General Robert Ross marched to Washington. That night, British forces set fire to multiple government and military buildings, including the White House, the Capitol building, and as well as other facilities in the United States government. In 1791, the standing U.S. Army was not as strong as it is today, and the state militias would be the main line of defense in case of an invasion, just like at Lexington and Concord. In the militia, the volunteers would provide their own weapons and oftentimes their own equipment. So if they could not own a weapon, they were not able to defend the state.
What are the limits of the Second Amendment's protection?
A well-regulated militia being necessary to the security of a free state, the rights of the people to keep the bear arms shall not be infringed. The right cannot be infringed by the United States federal government, but may be modified by the state because the state is in charge of the militia.
What weapons does the term arms include?
Today, the word arms refers collectively to offensive or defensive weapons. The word's meaning has changed little since it was first used 700 years ago. Its definition has never restricted civilians' use of military weapons, including when the Second Amendment was approved. Arms come from the Middle English and originated from the Old French word armes, which meant weapons of a warrior. This word dates back to 1300. Arms also originates from the Latin word for weapons, arma. This word was also first used in the 14th century. It's clear the meaning allowed for a very broad definition of what constituted arms. The Bill of Rights of 1689 states that the quote subjects which are Protestants may have arms for their defense suitable for their conditions and as allowed by law, end quote.
What is the difference, if any, between the verbs, quote, keep and bear?
The phrase keep and bear arms is also characterized differently today than it would have been in the 18th century. Many scholars attested at the time of the Revolutionary War to bear arms was an idiom meaning to belong to an organized military force. Bear arms today means to carry a gun. The idea of keep went to the fact that people had to be ready at a moment's notice to take up their guns and protect their homes when the militia called for them to do so.
What is a militia and why did the framers refer to it into the Second Amendment?
A professional military was completely anathema to most Americans at the end of the 18th century. Even James Madison, one of the most stalwart proponents of the strong federal government, noted in a speech before the Constitution Convention that, quote, a standing military force with an overgrown executive would not long be safe, end quote. This American dislike and distrust of standing armies was nothing new. It had its roots in English military history. However, even more notable was the colonists' own experience with the British standing army. In the lead up to the Revolutionary War, they had begun to view the British Army as little more than the enforcers of tyranny. In fact, the Second and Third Amendments of the U.S. Constitution can be understood as having been written in direct response to the conduct of the British soldiers. Not only did the British work to curtail colonists' access to arms and ammunition at the outset of the revolution, but colonists had been forced to lodge and supply British soldiers in the Courting Acts of 1765 and 1774. Hence, the framers of the Constitution were quick to enshrine the right to keep and bear arms, as well as the provision that, quote, no soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in the time of war, but in a manner to be prescribed by the law, end quote. It was our fear of standing armies that led the framers of the Constitution to emphasize the importance of militias. During a congressional debate on the crafting of the Second Amendment, Elbridge Gerry summed up this connection quite neatly. Quote, what, sir, is the use of a militia? Is it to prevent the establishment of a standing army? The bane of liberty, end quote.
How should courts determine if a gun control regulation is considered, quote, long-standing?
Look at the history survey done by No Hill, Texas State in 2018. Gun laws have been in place since the 1600s. According to Spitzer, quote, gun laws are as old as the country. More to the point, the idea of gun laws and regulation is as old as the country. Contemporary legislation such as concealed carry or the open carry movement ties directly to America's past. Current conversations about gun control are a review of what was in place before 1934, if not more. The distribution of gun laws within states and colonies between 1607 and 1934. This table shows the type of gun law, the total number of laws, and the number of states implementing said laws. For example, between 1868 and 1899, 5 states had passed 5 laws which banned guns. 28 states passed 48 laws which instructed the carrying of guns, and 9 states passed 11 dealing with manufacturing inspection.
What is strict scrutiny, intermediate scrutiny, rational basis review?
The strict scrutiny standard of judicial review is based on the Equal Protection Clause of the 14th Amendment. Federal courts use strict scrutiny to determine whether certain types of government policies are constitutional. The highest level of judicial scrutiny that is applied especially to a law that allegedly violates equal protection in order to determine if it is narrowly tailored to serve a compelling state interest.
Is there a difference between openly carrying a firearm and concealed carrying a firearm?
Concealed carry is whenever a person conceals a firearm, usually a handgun, in public, on their person, or in something that they can keep close by, such as a purse or a backpack. Open carry is whenever a person carries a firearm in public without concealing it.
How should the court consider the public safety implications of licenses to carry firearms?
The importance of this debate is in the heart of the U.S. Constitution. Does the state have the right to limit the right to bear arms? And we have shown that this right was exercised by the colonies of almost 200 years before the founding of the United States. And even in 1900, almost 75% of the states in the Union at the time had state laws dealing with different guns, weapons, or arms. To rule any other way in this case today is to tear up the Constitution and our rights completely. If there are no further questions, Your Honor, me and my partner will retire.